In sale of goods act, we have discussed the up till conditions and warranties. Now we have to discuss the two doctrines. First one is the doctrine of caveat emptor. This particular doctrine says that let the buyer beware. And what does it mean? What are the exceptions under which this particular doctrine will not apply? This thing we are going to discuss today. And another doctrine is nemo, that o non habet, right? So in this particular case, as per the rule, we say that no one can pass a better title than he himself has. So what are the rules, or what does it mean, that we'll discuss in this particular doctrine. No one can transfer a better title than he himself had, right? Now, when we talk about this first doctrine, doctrine of caveat emptor, so we have discussed about the conditions and warranties. We have discussed that the condition as to title, condition as to sale by sample, condition as to sale by description, mercantile quality, wholesomeness, fitness to quality purpose must be satisfied. Now, when we talk about the condition as to fitness of purpose, so in that case, we have already discussed that when a person buy a thing, so the goods should be of reasonably good quality, or should be used for a particular purpose, should be fit for the particular purpose. But whether the particular goods are fit for your purpose or not, that is to be decided by the buyer. So it is the responsibility of the buyer to see the fitment of the purpose of the goods. Fitment of the purpose of the goods. So whatever goods we are buying, we know what for what purpose we are buying, whether the goods are fit for our purpose or not, whether the goods are of the particular quality which we desire or not. For example, if we take one example that we wish to buy a pen. Now, whether this pen is to be purchased for the evaluation of answer sheets, or this particular pen is required for gifting purposes, and to whom you need to give that gift, what is your budget, what all other things are required for the purchase of the particular product, whether you need it to appear in the exam, whether the particular pen is needed, say, for any other purpose. Probably I need certain colorful pens to write certain things in the color form and all. So when we are buying a particular product, so for what purpose we are buying, this is known to the buyer, right? And once he select the goods and once he buy those goods, he has taken his own decision, right? And if this particular decision turn out to be a bad decision, how the seller is responsible? Seller is not responsible in this particular case, right? So every situation, it is just to you take an example that it is an article A. It can be any product, anything. If you want to, if you went to market, you have purchased a particular top, and when you came back home, your mom scolded you that you already have five black top, and again you have taken one more. So probably you're in a position to convince your mother that okay, I'm fond of this particular color and design. I was looking for this design since long, so I want this one. But there is another situation that you are convinced with your mother's words that yes, I already have number, so I can look for something new, some different thing. So you went to the particular shop and probably they, refused to take it back. But because it was in a sale, or the particular shop has already displayed that no exchange or no return, or there can be certain terms and conditions with respect to the return and exchange policies as well. So when buyer takes a decision, he is responsible to select the product for him or her and to decide that whether the particular product is going to be suitable for the purpose for which he is purchasing the goods. So there is no seller intervention, no role of the seller. But that particular good must have satisfied the express conditions and implied conditions. If it fails to fulfill those conditions, then the buyer has the right to set aside the contract, right? And with respect to the fulfillment of warranties, if these not will not be fulfilled, buyer can claim the damages or difference price for non-fulfillment of that. But without with respect to that the particular good does not turn out to be fit for the purpose or does not suit the buyer, that is not an excuse to set aside the contract. So in that particular situation, as per the doctrine of Cavet Emptor, it is the duty of the buyer to see that whether the goods are for his requirement or not, whether the goods are free from any of the defect when he purchases the goods, and if the goods turn out to be defective, he cannot blame anyone except himself. Also, there are if there is a seller, if there are any kind of defect which is apparent or which can be checked as a man of ordinary prudence, seller has no responsibility to disclose those defects, and there is an implied undertaking that the goods which are being purchased, that the buyer has to check that whether the good suits him or are good for his purpose or not. So if I purchase a particular pen, and nowadays on when we buy certain goods online, so there are the return and exchange policies, and we can do so, or even we can return certain goods, even if we have ordered the same, these have turned out to be the same, but still if we don't want, so we can make an excuse and we can return those goods. So these policies will be considered for the same. But otherwise, as a journal law, you cannot make an excuse by selecting the wrong product that turned out to be unfit for your purpose. So, in that case, the doctrine of caveat emptor is applicable, where the you can see the goods, where buyer has expressly told about the goods, and the buyer can, as a person of ordinary prudence, can see that the goods are in a proper order or not. The buyer has not rely on the seller's skill and judgment. He himself has taken the decision, and seller is not the expert in selling of those articles, and the articles can be used for different purposes. So whether it is good for your purpose or not, that is a different situation. And if a person is suffering from mental disorder or abnormality, and it has not been disclosed to the seller, so seller is not bound to give any decision, or seller is not bound to set aside the contract. He has the right to claim the price against the goods purchased by the buyer. But there can be certain circumstances where the doctrine of caveat emptor does not apply. And this particular, we can say, the situations will be known as the exceptions to the rule, let the buyer beware. So generally in the exam, this kind of question is being asked, that what do we understand by the doctrine of caveat emptor? Are there any exceptions to the rule? If yes, please explain with the help of the example. Please word may be ignored in the question paper. Okay. So the very first exception is that where the buyer has expressly told the seller the purpose of buying the goods, right? And along with telling that particular purpose, the seller is an expert in the area where we can rely on his judgment, and buyer has relied on seller's skill and judgment. He himself has not taken the decision, but he has gone with the seller advice or seller's explanation to the particular product. For example, A went to a particular showroom to buy a mobile phone, and he is not very technical or not having much knowledge about these smartphones, and even not aware of that what we understand by the expandable memory or the software or the other things. Now he expressly told the seller the purpose of purchase of the phone, right? And the seller is dealing in the particular goods, and he has suggested seller has suggested two models, Model 1 and Model 2, to the buyer. And the buyer has said that I don't have the knowledge, so you please suggest me out of these available models that which particular model will best suit my purpose. So, in that particular thing, seller has advised Model 1. He has purchased the Model 1, but Model 1 turned out to be not fit for the particular purpose. So, in that particular situation, the buyer has a right to set aside the contract and even can claim the price if he has paid for the goods, or the exchange of the goods can be there. And there can be a certain situation where seller has showed a particular sample, and goods are corresponding with the sample, and buyer has purchased the goods as these are matching with the sample, but buyer had in mind that this particular goods are fit for some particular purpose, right? And fit for purpose, and he has purchased the goods. Now later on he discovered that these goods not fit for the particular purpose, and he refused to pay the price to the seller. He cannot refuse to pay the price to the seller because he has made the wrong selection of the goods. He had certain misconception with respect to the utility of the product. So in that case he cannot set aside the contract. Here is a case law which is the Smith versus Hugs. In this particular case law, what happened that the buyer H is the buyer, and he has asked for certain oats which can be given to the we can say the race horses, and Smith has shown some sample, and after looking at the sample he thinks that this particular goods are suitable for the purpose, and he has purchased that, but these were not suitable for the purpose, and he refused to pay the price to the seller. So it was held that he is bound to pay the price because it was his selection that he has purchased the wrong goods. It was not the we can say the fault of the seller that he has suggested. Otherwise, if he would have asked, he would have expressly told the seller that this is the purpose of buying these goods, and seller is dealing on those goods, and seller has recommended the particular product. So in that case, the a buyer had the right to set aside the contract. Otherwise, wherever he has himself has taken the decision, so there he is not responsible. One case law of Bhagati car, where the car was required for the racing purposes, and it turned out to be unfit for the purpose, and the court held that the buyer has the right to set aside the contract, and the doctrine of caveat emptor will not apply in that case, as the buyer has expressly explained the purpose of buying the goods. Seller was dealing and was the expert in the particular area, and buyer has relied on seller's skill and judgment and have purchased the product. So in that case, the particular case law says that the buyer is not responsible in that case, so there the doctrine of caveat emptor will not apply. Other than this, first exception is this. Second exception is that where the goods are sold by description, then in that case, goods must correspond with description. The buyer is not responsible for the goods that if they do not correspond with the description. Where goods are sold by sample, goods must correspond with the sample, and that if these do not correspond, buyer has a right to set aside the contract. In that case, doctrine of caveat emptor will not apply. Where the sample and description being used to sell the goods, there also buyer is not responsible if it doesn't correspond with the sample or the description. And also when the goods are being sold in the, we can say, the in the name of the trade name or the brand name, so in that case, if the goods are being sold, so these goods must satisfy the condition of the merchantable quality. That means it must be reasonably good for the purpose for which it is being generally used. So if the particular goods turn out to be unfit or for the purpose for which these are being made, and this does not turn out, these are not of merchantable quality, then the buyer is not responsible in that particular case. So goods must be of some merchantable quality for the where the the for the whatever purpose the particular goods are being produced. Other than that, the condition as to wholesomeness of the goods is required. If the goods are for the eatable purposes, you are ordering some food from outside, so it is the decision of the buyer is not there. That can be there that it might not be that much tasty, or it might not be that much good as you are expected, but it should be free from any defect which can be harmful for human consumption. So that condition, there the condition of let the buyer beware does not apply. That buyer should have selected the right kind of the goods. The goods should be such that these are not carrying any item which is harmful for the human consumption. And as per the usage of trade, if certain conditions are being mentioned, or the after sale services being committed, or any kind of fitness for the purpose is there, so in that case doctrine of caveat emptor will not apply. And last one is that where the consent of the buyer is obtained by fraud. So if the other person has said that yes, this particular feature is there in the particular product, you buy this particular product, and the particular feature was not there in the particular product, so in that particular situation, the doctrine of caveat emptor will not apply. So in that case, the buyer can set aside the contract. So all these conditions we have already discussed in the case of in the chapter of conditions and warranties. So I think if you have any doubt related to this, you can ask. Otherwise, we can discuss the next doctrine in the next class. You can ask your doubts, please.